Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elevate.net, ELAWVATE.net, or go online to elevate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elevate.net or fill out a case workshop request at elevate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elevate podcast is brought to you by FileVine. FileVine has a software program called Lead Docket, which is the gold standard for managing your new case intakes and leads, your Gerry leads, your Glenn Ross leads, and all of your other leads. So check them out at FileVine and manage your leads. We're also brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute. Welcome to the Elevate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon. Rahul, you're dressed up. It looks like you're wearing a suit, at least from the waist up. That's rare for you at 6 a.m. What's going on?
I know. I'm headed to court right after our podcast, and it's been a while since we've done a recording, and I thought I'd dress up for this one. So,
well, it's only taken 5 years, so thank you. That's about time.
Feels like it's the right time.
What do you got going on in court?
Before we started talking on the podcast, this is fantastic news. You're headed over to Yale to do a symposium to the law students on being a plaintiff trial lawyer.
Yeah, as you know, a lot of law schools have started developing plaintiffs' law groups, and Yale now has a group, and they've invited me to talk about being a plaintiff's lawyer. So I'm really excited to do that, head back to my alma mater. And it's been great to see the development of that. Harvard's got one now. We're working on starting one at Maine Law School, and I know many law schools around the country have started them. And I think it's really great for law students to be exposed to the option of going into plaintiff's law, because when I was a law student, I had no idea that this was even a possibility. How about you?
No, it's fantastic. You know, I've been teaching over at Loyola Law School. I've taken a little bit of a break, but I reached out to the dean to get going at it again. I think it is such a great thing to expose law students at different schools to different areas of practice, and in particular, this area of practice, which is often overlooked at especially some of the Ivies. So that's really cool.
Yeah, I don't remember a lot of people at Yale Law School talking about wanting to put up billboards and handle slip and falls while I was there. there was a debate about who was going to be the next U.S. senator or vice president. But
Amazing.
I've enjoyed this career. It's been really wonderful, and I hope to share that with some of the other some law students so that they can understand not everybody has to go work for Goldman Sachs or Cravath. Um, so that's a good segue to our guest today, Jeremy D'Amico. So Jeremy, before we get into your background and all of your accolades, you went to Miami School of Law. Do they have a plaintiff's law section? Or?
I don't know that they would call it a plaintiff's law section, but as you know, probably down in Miami is one of the largest plaintiffs bars in the country. And what led me down to Miami was actually a really good advertisement that says, we pump out trial lawyers essentially. And I knew I wanted to be a trial lawyer, and so I went down there, and they have a program called Litigation Skills, and it's a 1.5 year to 2 year program if you really go through the whole thing. And you do trials. You have plaintiffs trial lawyers as your mentors. They come in, they teach once, twice a week. They come in, different faculty, different plaintiffs lawyers, and they really show you the ropes. And then your capstone for the course is you go to federal court and you do a trial with witnesses and things like that. And so it was really unique in terms of programs that I had seen, because there wasn't a program like that in Connecticut, which is where I'm from, and really just appealed to me. And I still keep in touch with some of my mentors down there. So it's phenomenal. It was a phenomenal program for me, right? You got to find your right fit, but that was a phenomenal program for me.
Did they bring any of the plaintiff trial titans from Miami into the classroom for
Oh
you?
yeah, yep, yep, yep. I mean, probably not, probably of the older ilk at this point, because you'd have to be a typical Miami alum, but like, Roy Black was a teacher. Um, you know, Harvey Sepler was a teacher. I mean, these are just gurus. And then there was a lot of people in the mentorship program. I'm not sure if you know David Bianchi, but he's a really well-established plaintiff's trial lawyer. He's got a niche in fraternity law, amongst other things, but really just phenomenal, phenomenal lawyer.
Well, that's cool to hear about. And just so we can give you the proper introduction, Jeremy is a stellar trial lawyer from D'Amico and Pettinici, which is based in Watertown, Connecticut. And I should know where that is, but where in Connecticut is that?
So from Yale, it's about 35 minutes north. Just travel
Okay.
right up Route 8.
So Jeremy's had some terrific verdicts that we'll get into. And as we mentioned, you went to University of Miami School of Law, and indicates in your bio that you led the moot court team there. So it sounds like you did a lot of trial work. And was the firm that you're at, was that started by your dad?
Yeah, so my dad, graduated law school in '86. Started, as typical fashion. He and two other associates at a firm, was at one of these larger firms here in Connecticut. Did kind of general practice, but they found themselves in the plaintiffs department. And then, like many trial lawyers, they said, we're doing all the work. Why don't we go out and start our own? So in 1990, the three of them started out, and then in 2000, a little bit after 2000, one of the partners decided to leave and kind of pursue his own endeavor. And so my dad and his partner have been doing it ever since. And, they're very good at what they do, right? So, it's not lost on me the blessing of opportunity that I've had afforded to me, and just inadvertent or incidental mentorship that you get over the life when you have, family who are good at what they do. But the fun story is like, growing up, they're like, what do you want to do? Right? You're 5, 6, 7, whether you're a teenager, whether you're early 20s, everyone's like, well, what are you going to do with your life? You're like, I don't know, I'm 18. Like, how am I supposed to know what I want to do with my life? Right? But ever since I was a kid, one of my earliest memories was, and I didn't know it at the time, but my parents couldn't put me in daycare for one day. And I found myself in a courtroom because my dad had to babysit me during his closing argument in one of his cases. And so I had no idea where I was, what I did. I didn't know what the decorum was. And so, here's 4 or 5 year old me. I'm just walking up to him, grabbing his leg, like asking for him to play with me, and he's talking to the jury, right? Like, he got a great verdict in that case. I don't know what what role I played in that, but there was something that gets ingrained in you if you're wired a certain way and have certain maxims taught to you throughout your upbringing that say, there's a real place in this world for people who want to right wrongs and for people who want to do good and do better. And for better or for worse, regardless of what the perception is of plaintiff's trial work, there's a reason why insurance companies and corporate wrongdoing fight so hard to curb this profession and curb justice, because there's so much value in taking away somebody's freedom or taking somebody's quality of life. It's, as we all know, priceless. And so having that power to be able to convey that in a way that resonates with people, regardless of what political belief you are, regardless of what your upbringing is, being able to articulate that and resonate the importance of that with those individuals is just an awesome power to be the person, the last line of defense, right, in any battle. And so that gravitated with me. That really resonated with me. It was something that I really wanted to do, despite having a plaintiff's trial lawyer as a father saying, you want to do anything other than what I do. You have no time. It's too stressful. I'd rather have you have a better quality of life than I did growing up. But lo and behold, I found my way back to this and am glad I did.
You don't sound like a guy who is stressed out. How do you manage it? Or does the job not stress you out?
I can't say that the job doesn't stress me out, right? Like, I think there's a little bit of recognizing your perspective in life. And when you certainly do our line of work, on any daily basis, you're working on X number of cases where people are catastrophically injured. Their lives have been turned upside down. Parents have lost a child. Adults have lost parents. And who am I to get upset because, my roof is leaking? So pain is relative, stress is relative, but I try to keep that in perspective, right? I try to stay grounded in that way. And my view of that is, and what I always tell people who ask me is, I have 10 fingers and 10 toes in a family that loves me. And anything else on top of that is just gravy. And so as long as my kids are healthy and my family's healthy, I'll take the lumps. Don't get me wrong. There's tough times. There's bad days when you're in the heat of trial and things are going sideways, or you're prepping and you feel like you missed something, or maybe you should have worked something up a little differently. It's stressful. It's stressful, but you always got to try to come back to, it's going to be okay. It'll work out, or at least it'll be the way it's going to be. And you can fight like hell and try your hardest to change the outcome and do your best, but you got to rest peacefully knowing that you did.
I'm curious. I'm always interested in the folks, and there's many examples of great trial lawyers who had successful trial lawyer dads or moms. And I always wonder about, that wasn't my experience. It wasn't Rahul's experience, but what's the balance between the mentorship and the lessons learned from your dad and trying to chart your own unique voice and identity? Have you found that you've more, kind of followed his approach, or are there things that you learned and then things you had to unlearn or do differently from your dad?
Yeah. So if you looked at me, I'm a spitting image of my father, right? And there's certainly qualities that we have that are similar, but we're also different. And so importantly, there was a level of trust that he afforded me and that he does, afford me in my work. And if you have a level of trust that affords you to chart your own path, make your own way, you're going to develop your own style. You're going to develop your own niche of how you do things. But you have to recognize that if you're not in a position where somebody's giving you that freedom, and this applies to any mentorship, right? Like whether it's a parent, whether you're at a firm and you're working under a partner or something like that, you have to have the ability to, make little mistakes, right? Chart your own path, find your own voice. And my upbringing, I've always challenged the status quo, right? So for annoying or whatever you want to call it, I've never stopped asking why. So why do we do it that way? Why? Why is it valued that way? Well, that's because that's what I've settled other cases for. Why? Well, I don't know, because that's what they settle for. Why? And so you learn techniques, right? But I think if you ever feel like you ever stop learning or need to stop learning, then I think you have to reevaluate that. And so balancing being able to have the freedom to make your own mistakes, be your own voice, be your own creature, with having trust, which is earned, right? You got to earn it. So you got to be constantly improving, constantly educating yourself, going to different trial organizations, listening to podcasts like yours, doing all of these things to continually improve, to earn that trust, right? To say, oh, okay, I'm going to allow you to do that, or we're going to let you take that. So within the first couple months I was here, I was trying cases. And I'm very thankful for that opportunity, but we do have personality clash, right? That's gonna come. There's no, I'm 30 something years old at this point. I've known my dad my whole life. And so you're gonna butt heads, and it's understanding what you're butting heads over that really matters. Say, oh, okay, why are we having a disagreement about this? Right? Ask why. Okay. And there might be two different approaches to a strategy. Is one better or not? Let's talk about it. And so that was a hurdle in the beginning, not so much now, but that was a learning curve for sure. And it was one of the reasons why I went down to Miami. Like I didn't want people in my legal community in my school. I didn't want the fact to be like, oh yeah, I know your dad. Like no problem. Blah blah blah. No, nobody knows him in Miami. So I went down there. I wanted to make sure that I could do it my own way and have success in my own voice, and it worked out.
Now, you say you're a spitting image of your dad by looks, but how about personality? Do you present in a similar way in the courtroom, or how do you see yourself differently?
I think we present differently in a courtroom, which I think helps a lot. He's very I don't want to say stoic, but very methodical. He's very methodical. He's very even keeled. And I'm more animated, different tones, inflections, different energy, a different way about me. And so we usually split up roles when we try cases together where, he'll do the opening, he'll tell a story in the way that he does it. And I always close. And it's just kind of the impact that we have and the dichotomy that we have. But we always incorporate and make sure that when we're trying together that those styles are mirroring what the case needs and what the witnesses need. A certain witness might need a certain approach. And so we'll say, okay, you're going to take that one because I think that approach will work better for this one. Or, okay, I'll take this one. And same thing on cross-examination because, as part of successful trial work is you're really, you're directing this, right? Whether you're a producer essentially. And so you need to think about, how is this witness going to present? What is the information that we need to get out of them? And more importantly, how is the audience going to absorb it? and what's the way that we need them to absorb it? And are they going to absorb it better from a more methodical, measured approach, or are they going to have a more emotional reaction and need to get a little excited or have a little pizzazz about it? And so we work off that way. And so, things that I've learned from him is he is super investigatory, which is an amazing quality and something that I continue to learn from him and strive for him. And so, I ask questions about, well, why do we as trial lawyers do things this way? And he does a very good job of asking questions substantively about the case. Why? Which I think if you're any trial lawyer, if you got to do that. And sometimes, you can put blinders on and think your case is X. And really, if you're continuing to ask why, your case ends up being Y or W or pick a letter. And he does a phenomenal job of exploring all that to make sure that, by the time he gets to trial, everything. And I'm very blessed to have that opportunity to learn that from him. Very, very blessed.
So I see that you went to the Gerry Spence trial lawyer college program and graduated from that. Can you tell us a little bit about what you gained from that experience?
Yeah, last semester before the big divide.
Oh, okay.
So it was back in 2019. And I think what I took away most from the Gerry Spence College and that approach is, putting aside psychodrama and these other techniques of really, developing your witnesses, you have to develop yourself, right? Like that was a perfect time in my life to go to the ranch and kind of do that, because Rick Friedman wrote a book called The Way of the Trial Lawyer. And
he was our very first guest. We talked about his book on that.
Yeah. And you really have to be authentic to yourself. And if you don't know who that is, or if you don't know what your passion is or how that works, anything that comes out of your mouth at trial, people are going to be suspect, because for some reason, subconsciously, I think people can identify the quality of things or the authenticity of things. There's another book called, I think, the Zen of Motorcycle Maintenance or something like that, which I've also read, which went way over my head when I read it. But the concept really is people understand the quality of things, but you can't really explain it. And I think the same thing comes with authenticity. And so you're 3 weeks on the ranch, no cell phone service, no technology, and you're just with a group of individuals doing, trial skills and trial adjacent things from sunup to sundown into the night. You bring your cases, you do your real trial skills, things like that. And that was right before I tried the bus crash case with the boy with autism. And literally I came back, and a week later we picked the jury, and 3 weeks evidence later it's a $23 million verdict. And I owe a lot of the presentation of that case and the strategic workup to things we did at the ranch, and understanding who I was in my perspective and how the quality of life matters to me in order to be able to convey that to others on behalf of the young boy. So really phenomenal experience. I know that things have changed quite a bit now, and there's a little bit of a dichotomy now in different programs, but super impactful place.
Do you have an example of something that you employed from the ranch in that particular trial? If you could let everybody know just generally the facts of the case, and then give us an example.
Yeah, so that case was a young boy with autism was on a school bus, and it was on the way home from school, and there was a crash, right? So now you're like, all right, what happened here? And it turns out from interviews with the bus driver and witnesses that the bus driver was saying that a car had veered into his lane, causing him to veer over to the side of the road, and there was a very large tree that he could not avoid. And when he hit that very large tree, he hit it in such a way that the roof of the bus collapsed on the head of a 12-year-old boy with autism. And the witnesses behind the bus, which was a line of cars, 3 cars in a row. I said, we didn't see any car. We don't know what he's talking about. I feel like if there was a car that veered into the lane, we would have seen it. But there was one boy on the bus who they had a private investigator speak to, who gave a statement that said that he did see a car, but he didn't see it veer. And he couldn't really provide any more detail than that given his condition. And so a large part of that case was, well, how do you present damages, and how do you really convey what happened to this young boy, because his autism was such that he was nonverbal, and he wasn't very high functioning in terms of like social education and social interaction. And so the whole defense argument was, well, even if he did have a brain injury, which we don't think he did, how much could it have really changed his life? And as much as I want to take credit for being able to convey a really great story of value, quite frankly, I think that kind of pissed the jury off. That's kind of a bad approach, if you ask me. So that was the case, and then so one of the hurdles was there was a dichotomy of responsibility between this phantom vehicle and the bus company. And what we did that I took from the ranch was I put the jury on the bus. So I put a chair right in front of the jury box, and I was the bus driver. And I sat down and I put us on the road as we're driving down the road, and I had a PowerPoint screen with the road in front of us, and we all drove on the bus. And what I was trying to convey to them was, there was signs and signals that if there was a vehicle up ahead, that the action that you took, you shouldn't have taken. You should have done a different action. And so, you start the car, this phantom car, half a mile down the road, a mile down the road on a straight road that you can clearly see. And maybe it comes close to the yellow line and goes away, and comes close to the yellow line and goes away as it's coming towards you, which kind of signals to you as a driver, what's this guy doing? And what you don't do is speed up towards it, right? And so I think that was super helpful of a technique to literally turn the courtroom into the scene. And by the time that the car veers the third or fourth time and comes over into this side of the road, everybody's like, what's the bus driver doing? Like, why aren't you stopping? Why aren't you slowing down? We're going to hit it. Mm-hmm. Right? They're in their head, the jury's thinking like, we're going to hit this guy. And so that was really impactful. And so they blamed the bus driver 90%. And I think the car 10%, I believe, was the dichotomy. It might be off a few percentage points, but super impactful. And I did the same thing in the ICU. So, the young boy can't explain the scene. So I had parents explain the scene. Okay, you're walking into the room. What's it look like? What sounds do you hear? What machines are going on? And so the jury's hearing, it's this white room that's dimly lit. It's got kind of this musty, but eerily clean, sterile smell. It has the beeping of the EKG machine, and it has the O2 sensors, and we can see the IVs hanging, and my son's just laying in that bed. Right. So you expand an event that you kind of take for granted, and you blow it up into something that's so visual and visceral. And the last example of a similar concept was I made the courtroom during the closing argument Gabe's brain, and we were all inside Gabe's brain. And we were looking at neurons and diffuse axonal shear, and being able to see how that works and how that jives. And so those visual concepts are just so important.
Yeah, that's all really powerful, and the way you communicated is incredibly effective. I'm curious, those techniques, did those come out of your experience at the ranch, or are those things you were experimenting with before that? or part of your repertoire before that? And was there something that you had to learn about yourself that allowed you to execute those techniques effectively? Because as I listen to that, I have lots of thoughts, as I'm sure all trial lawyers do, and try to projecting our own self and how we would handle that and what would work for us or not work. And some of those things I feel could work well for almost anybody. Some of those things could work really well if executed well, but really poorly if executed poorly. Some of them could backfire depending on how it's presented and received. For instance, I'm thinking about the sitting in the jury and being on the bus scenario. I wouldn't know intuitively whether that would work or not unless I tested it. But I'm just curious about a lot of those thoughts about those different techniques. But I guess fundamentally, what did you have to learn about yourself or overcome to effectively execute those creative techniques in the courtroom?
True belief, right? I can't tell you in early on in my career the number of cases where I would tell a number and I could tell I didn't believe the number I was saying. Whether I felt it was too, whether I thought the number was too low, but I thought a jury wouldn't believe a higher number, or whether my own personal belief on the case was the number was too high and I didn't believe it. And they can sense that. I feel like the jury can sense like, oh, this guy doesn't believe his number. I have visceral reactions of, two cases in my head where I'm like, yeah, I didn't believe that number. And I feel like the jury saw that, both times that happened. And so, I don't know that it's necessarily a technique at the ranch that helps you learn that. But what it did was help me understand the importance of how I value life and living and enjoying things. And, Rahul, you're mentioning like, I seem somewhat unbothered by stress sometimes. And I think that comes from an appreciation of how wonderful my life is compared to others, right? And so you necessarily learn at the ranch because there's nothing else to do. You necessarily learn introspection if you haven't already been on that journey beforehand, and piecing that together. And then it certainly helps that Josh Carton was there to help you, identify, well, no, if you're going to tell kind of this story in kind of a theatrical way, like here's some elements to incorporate, right? And so certainly that was impressive. But if you're thinking about, scene setting in the courtroom and you yourself think or have any doubt in your mind that it's going to look stupid or it's not going to come across right, in my view, it probably won't, right? If you're thinking as in your head, this is going to look stupid, there's going to be doubt that energetically may resonate with the jury and be like, I don't know that he really believes this or this illustration. But I can tell you that, right, that worked for that case, right? Because a theme of that case was all about, we know he can't convey to us exactly what's going on with him verbally, right? We know that. So we have to have all of these techniques to employ to try to show you that and bring you there. In the $45 million case, a couple months ago at this point, I didn't use any of that. It just wasn't right for that case, right? I didn't think it needed it. It didn't resonate with me as being authentic for that moment or that case. I used different techniques, right? I used the domino theory, right? And I actually used real dominoes, to establish causation. And so that was kind of that illustration of that point. But it wasn't like I set the whole scene of, we're on the road, we're driving towards, there's a visual obstruction, what do you do kind of thing. And certainly not in the way that I did it in the other case. And so when I was practicing it, like I tried it out and it just didn't feel authentic to that case. It felt like I was trying to do the same thing I did in another case just because I did it in another case. So I asked myself, why? right? And the why I wanted to do that initially was, well, I got a great result in the other case, so let me just do the same thing here. But that's not true to this case, right? So I had to find my authenticity of this case in that presentation here, and really find what's going to resonate with me about that case in presenting that case alone. Because I think there's maxims that apply or tools that apply to every case, but you can't use, not every tool is right for the job.
It's great. And that's what's fantastic about having all of those experiences like you were talking about, is you get all those tools in your toolbox and you learn how to use them, and then you learn when to use them, and that helps you grow every single day. That's fantastic.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
So, Jeremy, on that more recent case, that was what piqued my attention initially about you, because I don't know the facts. What I know about it is only that the case involved a motorcycle crash, and the theory had to do with another vehicle that was parked that was obstructing line of sight. We have a similar case in my practice, so when I saw you got that verdict, I was very curious to hear about how you put it together and the facts of it. So do you want to just kind of give us the summary of it, and then we can jump in and ask you some questions about it?
Sure. Yeah, so we represent a 22-year-old Marine, right? He was a Marine reservist. He was a local kid through and through. Had a little bit of a problematic upbringing with some absentee fatherism, and really, by all accounts, was just a really amazing human being. Every punch that was thrown at him, he took it in stride and really tried to chart his own path, and one of the guiding principles of that case on the damages theory for us, and trying to convey it as best I could, was he really tried to be everything that his father wasn't to him. Like one of his missions and goals in life was to be the father to kids that he never had, right? And that was taken from him. So we started with that premise in terms of a damages theory, and then from a liability perspective, he had left his house, he had traveled on a road he had traveled 1,000 times before in his life. His crash happened only a mile from his house, and he turned on Main Street, which was a very main thoroughfare. It's a route, but like, as I'm sure in Maine, you have routes that go through, city centers, and then they turn into more rural and whatnot. So it was a relatively throughway. Speed limit's 25, right? Posted speed limit's 25 on that road. And he's driving his motorcycle, and he's just driving along. That's all he wanted to do. And there was a vehicle who was trying to pull out from a tow yard. This vehicle that was trying to pull out from the tow yard was there to pay for towing fees on another vehicle. And so they were leaving, and as they were leaving, they can't see past this tow truck the way that it's parked. The way that this tow yard is specifically set up is it's super close to the road. I mean, super close to the road. And so for some reason, the owner of the tow yard, when he parks his tow truck, he parks it halfway on the sidewalk, halfway on his property. I should say a third on the sidewalk, a third on his property, and then a third into like a private right of way that accesses other properties. So it's kind of like a common use easement. And so this person who's trying to exit is, trying to see around it. So they do that kind of like lurching a couple times, like they stop and go, stop and go, stop and go. And they do that 3 times. Meanwhile, our guy is just driving up the road. He doesn't know that the car is trying to stop and go until about the second or third stop and go. And right around the second stop and go, just after it, he thinks in his head, he's like, oh shit, this guy can't see me. Right? So he says, well, I got to get around this guy. So he speeds up to try to get around the guy. And when the guy who's pulling out edges forward again and then stops, our guy naturally thinks, oh, good, he sees me. The problem is he still can't see him because the tow truck's there. And so now he just starts to go because he's now stopped and gone 3 times, and he's like, well, I guess I just got to go. And so, as you would expect, our motorcyclist who's accelerating and that car just collide and smack each other, right? And, unfortunately, he goes flying and, breaks his back, and, he's paralyzed from the waist down. He's got no bladder control, no bowel control, no sexual function. I mean, just destroyed physically and emotionally for the rest of his life in dealing with that. And so, the defense theory was, this guy was caught on surveillance video in front of the tow truck going, 66 miles an hour. So, he's going 66 in a 25, what an idiot, it's all his fault kind of thing. And if it's not all his fault, it's partially his fault, and it's partially the fault of the guy who was pulling out, because why would you pull out if you can't see? Essentially the tow truck had nothing to do with it. And then they disputed that the tow truck was not parked on his property or his premises. And so, we started asking why, right? So why was he going 66 or 67? Like, why was he on that? So you start asking witnesses, you start getting the story, and you start piecing it together, and it turns out he wasn't going 66 the whole time. It's not like he just turned on Main Street and decided to goose it to go 67 up the road the whole time. He was trying to take a defensive acceleration to make what he believed was the safest course of action he could in that moment. And so that's what we argued in that case. And we argued primarily the theme of the case was, if you take everything else away, none of this happens if that tow truck's not parked where he parked it, right? That SUV, everybody agrees that SUV doesn't pull out because you can see. Everybody agrees that our motorcyclist doesn't accelerate to 67 if that tow truck's not there. So my domino effect was, I placed dominoes. I only used 3. The tow truck was one domino, the motorcyclist was another domino, SUV was another domino. And, I put the chain of events and I knocked him over. And then I took the domino that was the tow truck and I said, but what if the tow truck was parked where it should have been? And I physically picked the domino up and I moved it where it should have been parked. And I knocked it over. And the other 2 dominoes don't fall. Right? So that was the concept of causation there, right? Like, yeah, he was speeding, but that doesn't matter. Or, yeah, the guy pulled out, but that doesn't matter because the first in time harm was this negligently parked tow truck. And so, you have all your challenges in that case. Motorcyclist, young 22-year-old who, people would probably think is a risk taker, right? Just by nature of the stereotype. He's in the Marine Corps, not adverse to, combat or, risk-taking behavior. He wasn't wearing a helmet at the time. So all of those types of internal thoughts of people who have preconceived notions that way are things you really need to consider. And one thing most people don't know about Connecticut is we have what's called individual voir dire. It's a constitutional right where we have the opportunity to question every jury one-on-one. And most of the time that takes, 30 to 45 minutes to question one juror. And you get to ask them, essentially anything you want, right? There's limits to that. But you have a lot more freedom to ask those types of questions, and there's benefits.
In an empty room? So is it one juror with the 2 lawyers and nobody else?
That's true. Yep. So the pros of that are, some belief that people are more comfortable opening up in that way when they're not in a group setting. The con to that is you have very little opportunity to get any tribe building, right? No, you don't get to identify the rapport. And the other thing is you don't know who's coming next, right? So you don't get an opportunity to say, well, if I'm stuck with these two people, which one's the better one for me? You have to do it one at a time in the order that they come. But
How long does that take?
so in a case like this, 2 weeks. Every day, if you're picking a jury, it takes 2 weeks. You have a panel of 6 plus 2 alternates generally, and it's a unanimous verdict. So it's if you haven't done it, it's a different experience. You lose some of the tactical advantage of like preparing a really good voir dire to a panel, because you're like, oh, the defense isn't going to ask these questions. They're not really going to understand why I'm asking. By the third day of individual voir dire, there's no hiding anything. Like everybody knows what you're asking and why you're asking it. But you have to explore those feelings, thoughts, opinions in your voir dire. Like, hey, how many people think that, just because this case has a motorcycle speeding in it, that they're automatically comparatively at fault for their own crash, right? If you don't explore that, you're going to get that person on the jury. And so fortunately, for whatever reason, in this particular pool on every day, people were pretty forthcoming about, what was important to them, and admitting like, yeah, I see lane splitting motorcycles all the time. I see young kids doing this all the time. Maybe this just isn't the case for you. And they're like, yeah, maybe it's not the case for me. Okay. Same thing. Oh, he wasn't wearing a helmet. Okay. How do you feel about that? Oh, well, he's an idiot. Okay. Well, how are we going to handle that? So you just kind of develop techniques to either get them to recognize and be comfortable admitting that that's not the case for them, or you find some other really good way and really good concept to cause challenge them off, on burden of proof or money damages or things like that. And that worked out really well for us in this one.
Was there any apportionment of fault, or was it all on the property owner?
Yeah, so they did apportion. I asked them to apportion 10% to our client. We told him at the beginning, because there's no way he was going above the speed limit before he accelerated, right? And so if your posted speed limit's 25 and you're going 35 or 40, even if it's the flow of traffic, technically it's what they call negligence per se here in Connecticut. And if you try to fight that, it's silly. And our client was, no, I was speeding. Yep. I was speeding before I sped up. Do I think I caused this crash? No, I don't, but I did it. And we told him in jury selection, we're going to admit this. Just because we admit it, do you think that other people could still be at fault or more at fault, even though we're admitting our portion of responsibility, which we'll talk about? And so we told him in jury selection. On direct exam, he admitted it. And then in closing, I said the same thing. I said, listen, he was going above the speed limit. He owns that, right? But he was not the primary cause of this crash. So, as we told you, we're going to give him and we're going to ask you to give him a little bit of fault. We're going to ask you to give him 10%. And that's what they did. And then they did 65% on the tow truck, and then 25%, if my percentages are right, 25% on the guy who pulled out, which was pretty close to what I asked them for.
How did you decide did you use any big data focus groups or any other types of things to decide this approach?
Yeah. I mean, we had thought, early on, there's going to probably be some apportionment of responsibility here in some way. And then we've always done focus groups in-house. We have an in-house courtroom, and we did 3 focus groups on this case. We did 2 big data studies on this case. We used Campbell's for our big data studies. And then we also hired a jury consultant who was also wonderful. And so we kind of put all of those pieces together to try to figure that out. And information was different depending on which group you got, right? And because of all of the different information that you would get, you'd continue to refine your approach. You'd continue to refine your arguments. And then eventually you just have to go with what you authentically believe in the case, right? And so you kind of take all those inputs and you say, okay, I have permission now to feel this way about this case, right? Some people use the data studies to validate and have a stronger belief in like, it's not crazy for me to ask for this amount of money, or it's not crazy for me to ask for this type of apportionment, right? So now they have some external source that makes them feel better, like, oh, okay, this is validating for me, and now I know that when I say this number, it's not just me pulling a number out of thin air or my calculations or my belief. Other people believe that too. So it's empowering in that way. And so, on the monetary ask, or, even on how to conceptualize or argue the damages or the liability in a certain way, you have to use all of that. You have to use all of that.
It's really, if you were going to design the perfect case for a trial course that involved a plaintiff personal injury case, this would be the case, because it has so many elements to it that are seemingly simple, but are very challenging in the kind of work we do, and so many potential landmines that you had to thread the needle to get to that amazing $45 million verdict. I guess, you've given us kind of the description of the facts, but can you bring us inside the courtroom a little bit and tell us more about how that played out, the drama of it at trial? And I'm curious how the defense lawyers handled their positions as well, because those are also seemingly a little bit fraught.
Yeah. So simplifying the case was important, right? So on the other side here in Connecticut, it's a really, really great defense firm, really great lawyers on the other side. In fact, I teach a trial course, and I've taught a trial course for a decade with a partner at at this defense firm. So I have really good respect for them. We have a great relationship with them, just good people, which is always helpful, when you're trying to work through issues in a case. But simplifying it was important, right? So when you're talking about liability and damages, like who do you actually need, right? We as lawyers have a tendency to overanalyze, importantly so, but to overanalyze the case and potentially over-expert the case. Something that might be seemingly simple, our lawyer brains say, maybe I need an expert for that. So we ended up retaining and disclosing 2 human factors experts. Ben or Rahul, you may be familiar with Jeff Mootart. He has the Driver Research Institute. He's got an office in Connecticut, but he's also got one in LA, which is why I'm not sure. But he's like the guru. He wrote the book, on driving behavior and perception, reaction time, human factors, all that jazz. So we retained him. We retained an expert out of Canada, also on the same point, a human factors expert by Dr. Rudin Brown, also lovely. Then they disclosed, a human factors expert. We had an accident reconstructionist. They had an accident reconstructionist. And when push came to shove, you said, okay, do you actually need a human factors expert here? Do you actually need an expert to explain to the jury that this person could not see? And you're like, well, no, I don't. And so we didn't call our human factors people, which means they didn't call theirs, which took 3 expert witnesses out of the case. And so not only does that do that to streamline presentation, but it also streamlines, the lack of a cross-examination of those witnesses, right? Reducing bites at the apple to highlight potentially bad facts of your case. So, we probably took 4 days out of the trial just by doing that. So that was a good strategy decision. We ended up just calling our accident reconstructionist and their accident reconstructionist on that issue. And then for damages, I'm always a big proponent of fact witnesses, right? So I can't overemphasize how important the plaintiff was, right? Like, he was unique. He was wonderful. You could not root for this guy harder. And, but not from like a sympathy basis, just like he's just objectively a very good person and he has a lot of harm. So it's not like of course you felt bad, but you're not going to do anything about that. But he had a wonderful mom, he had a wonderful sister, and, you spend hours, days with them, just trying to figure out, like, what's your story? Let's go to your house. Let's see how you interact here. Like, what's actually difficult for you? What, because they forget this stuff, or they don't even pay attention to it anymore because they've just gotten used to just trying to live their life. So you present all of them, right? And you figure out how to do it. We presented a life care planner. We presented his spine surgeon who performed his spine. And everybody has a role to play. I've moved off of the theory that you got to get every witness to talk about everything. If they're qualified to do it, or if they have some information about it, let them say their piece. I've gotten off of that, and I'm more so like, this one witness is this puzzle piece, right? And it's really helped focus those examinations. It focuses the examinations for the audience. It makes things quicker. And so a lot of strategy went into, what piece of the puzzle do I want this witness to talk about? I know you could talk about this, and this, but which one do I need you to talk about? It eliminates redundancy. And I think hopefully that the juries recognize, like, okay, we're not trying to waste your time. We're just trying to give you the information that you need to make a good decision.
Can you tell us a little bit about visuals? Did you have, an animation? Did you have some effective visuals that illustrated the principles you were making about time, speed, and distance, and locations? Tell us a little bit about that.
Yeah. So in terms of visually, what we did is we worked with our accident reconstructionist. His name's Dana Thornton out of Michigan. And he did a really phenomenal job presenting the case. And he and his team internally have 3D software. And so what they did is they took the surveillance video. They were able to do a process called camera matching and photogrammetry to place the vehicles exactly in the precise locations in a 3D environment based on that video surveillance and the photographs of the scene that they had. And then he was able to reconstruct backwards, a number of different examples of, if he was going at this speed, or if the vehicle was doing this is how this plays out. And he had a whole PowerPoint presentation that was his direct examination, where he went very methodically through how he arrived at his opinions, what he did. And it was just so helpful. And he did a really good job of tying it to the fact witness testimony as the basis for the animation, or the reason, or the principle he was trying to make. And I think that's super important in terms of telling an expert's story. Right? A lot of times we ask the expert, like, okay, what's your qualifications? What's your opinions? But we don't necessarily do a really good job of, during that direct examination, pulling up facts that are helpful to us, or even facts that we think are challenging for us, and letting the expert really explain how it is that the factual information at the relevant point in their testimony matters, and explains that to the jury. Like, no, okay, this witness said this, and this is why I did this. So let me walk you through this animation and why I plotted this here, because this witness said this. All right, well, did anybody else give you any information on that? Well, no. Okay, so that's why you picked that. Yes. Right. And so it allows the jury to say, okay, well, I heard that statement from that person before. I heard that. Now I get how it all works together. And so the animation that we had not only was like a top-down overview of watching, like, the motorcycle come down the road and the vehicle pull out with the parked area of the tow truck, but we also had a POV view of what the driver would have seen pulling out, and looking in the direction of the motorcyclist at each stop position, or as he was driving forward. And all you see is tow truck. Like, you would think that maybe they could see something, but when you see that, like, there's just no way. Like, that's so impactful to know, like, this guy couldn't see no matter what. And the last opportunity he had to see, it was too late. It was too late. And it also kind of does a good job of right, setting the scene, but it's not you doing it. It's showing them, like, here, be in the car. This is what it's like to be in the car pulling forward. So we used all that. We then had a land surveyor. We used the town engineer and a hired land surveyor to actually plot in a 3D environment the tow truck on the property boundaries, right? Because he was claiming he parked fully on his premises, and we did deed research and whatnot. And then we color coded the map in the 3D environment to say, like, no, here's the right of way, your tow truck's clearly on that. Here's the sidewalk, your tow truck's clearly on that. And here's the corner of your property. And so you just kind of visually, conceptually make it really easy for people to be like, oh no, he's clearly not on his property, right? So you tie all that into the expert.
That sounds like one of those I just can't get over it facts.
Exactly.
I mean, he's breaking the law, and that seems self-evident. And if that has a causal connection to the crash, that seems like a pretty powerful position. Would you be willing to share your visuals? And if they're publicly available at this point, we could put them in the show notes so listeners could access them.
Yeah, let me see if I can get them. I know I have some of them. Let me see what we used in the court and presentation. No problem.
Okay, that's terrific. Well, boy, Jeremy, we've reached our hour here. It's just flown by, and it's really fascinating to hear about all your cases and trials. And I really appreciate your coming on and sharing all this with us.
Well, I appreciate it. I appreciate what you both do. I mean, right. So in terms of continuing to educate yourselves, right, and educate trial lawyers, right, people who do what you do and try to vocalize that, voice that, be a megaphone for consistent education is rare. You know, there are great lawyers who do it. You two are among them, but it's rare because it's so busy, right? Your lives are terribly busy, and yet you're still taking the time and setting aside time to be a megaphone and a resource for trial lawyers who want to be dedicated in honing their craft to learn information from anybody who wants to share their knowledge and experience. And so thank you both for giving people the opportunity to do that.
No, appreciate it. I mean, I'll tell you, and I say this all the time, I learn, I think I get more out of this podcast than anybody else. So getting to meet you and other great lawyers across the country, it's, I continue to learn and try to employ things that I learned from you and all the others. So thanks for being on.
My pleasure. My pleasure.